Time now for Night Court. Several former pro wrestlers claiming that the WWE failed to protect them from repeated life-threatening injuries are taking their case to the Supreme Court. Earlier this week, the High Court declined to hear their case, but we're going to take it up tonight with criminal defense attorney Bob Bianchi and attorney Andrew Stoltman. All right, guys, so a lot to dig in here, even though the Supreme Court decided not to take it up. But, I mean, this is a suit that was brought forward against the WWE. A lot of former wrestlers signed on. And I'd like to pop up Exhibit A from the original lawsuit. It reads, quote, WWE wrestling matches, unlike other contact sports, involve very specific moves that are scripted, controlled, directed, and choreographed by the WWE. As such, the moves that resulted in named plaintiffs' head injuries were the direct result of the WWE's actions. So, Andrew, you are arguing for the wrestlers. Make your case.
That sums it up perfectly. This isn't a situation where you have a football player where you can say, look, this football player put his head too far down low and then he got a concussion. These people were being scripted. They were being told what to do, and the results speak for themselves. Some of my biggest idols as kids, like Jimmy Superfly Snuka and King Kong Bundy, they died of CTE, and the WWE is to blame, and now they're trying to disclaim liability, not pay any damages. They're going to be successful getting off the hook, but that's unfortunate.
I mean, Bob, I'm just looking at some of this footage here. You can see how some of these wrestlers could get some serious head injuries. You're arguing for the WWE. Make your case.
Yeah, this isn't a no-brainer. The judge wrote a 40-page decision that I have here after it had twisted through the courts for a significant period of time. And the fact of the matter is they were unable to prove that they had knowledge of this condition. The lawyer in this case was rebuked by the judge over and over again with regard to having complaints that were over 335 pages, 225 pages, was superfluous, inaccurate, hyperbolic, inflammatory, and unrelated to a recognizable cause of action. What essentially this lawyer was doing was saying that articles in 2013, 15, and 17 show that WWE should have known about this. The problem was those people had left the employment of the WWE decades earlier. So there was nothing, the judge said, nothing that could prove that this case that WWE should have known. And I'll add one thing that I think even my esteemed colleague here would agree with. I have never seen a judge write an opinion, and I've been doing this a long time and practicing in federal court, where she essentially said from this point forward, we're sanctioning the lawyer for what could be up to $500,000 in damages that he, the lawyer, has to pay it, not the client, and includes in her order that from this point forward, the lawyer, for any future, current, or former wrestler for the WWE that he accepts as a client, has to be given a copy of this court's order with respect to what this lawyer did in terms of not complying with the civil rules of procedure in federal court. It was a no-brainer. Supreme Court would never take a case like this up.
All right, so Andrew, do you think that the Supreme Court should have taken up this case?
No, look, I don't. And the Supreme Court only hears about 1% of all appeals. But the NFL paid out over $1 billion because they knew they had liability. And to argue that the WWE didn't know, legally, that's what we call willful blindness. The WWE didn't want to know because the money and the profits were coming in. To now bury your head in the sand and say, gee, we had no idea, it's disingenuous, it doesn't pass the red face test, and it's BS.
Yeah, but here's the issue. The judge gave them 4 opportunities to present evidence after discovery, interrogatories, and depositions, and the best that they could come up with, the plaintiffs, was that there was another WWE wrestler that had traumatic brain injury, and the judge was like, that does not put them on notice, and plus that occurred again after these people had left. The simple fact is the plaintiffs just didn't bring a factual case, and the judge is required under the law to dismiss a case when there are no facts to support it.
All right, Andrew. Oh, okay. Well, you've got 10 seconds. What do you want to say?
Maybe bad lawyers, but you have real victims. I love Jimmy Superfly Snuka, and it's a shame that he's gone and he died because of this.
That is an excellent point. Gentlemen, thank you so much for debating this. I really enjoyed it.
Thank you. Thank you. Pleasure.
And finally, we've got